Okay, Mr. Rosenberg. All right, I think we're all set.
Thank you and good afternoon. What a pleasure to be before the court in this context. Your Honors, there are two distinct issues on this appeal, and I don't want to give one more significance than the other by addressing it first, because I think they're of equal import to the court. But we're talking about a claim that Mr. Ernst did not exhaust his administrative remedies with regard to his sexual orientation claim, and then we're also dealing with whether or not he was able to maintain or produce evidence of a prima facie case on the race discrimination case. I think it's important that I speak first about the exhaustion case.
Let me just set that. Certainly give you every bit of time you want to discuss that. So on exhaustion, I mean, one of the primary purposes, as you know, of exhaustion is to give notice of what the claim is, but your client was kind of confusing or at least inconsistent. The EEOC complaint alleged only race, and then the intake questionnaire listed some other claims, so the whole concept of notice was kind of dissipated. I'm setting that up for you so you can respond.
No, and I anticipated that, and I think there's a couple of logical explanations to it. Number one, okay, back at the time when Mr. Ernst when he visited the EEOC for the first time, that's 2 years before the before he came to us. This case was pending at the EEOC for a while. One thing we have to remember is that Bostock was not yet the law. So the EEOC could not, in all rightful context, proceed on a charge that the protected activity was not yet before. Bostock is relatively recent, as you know, and we all know, based even as recently as last week in Judge Smith's opinion in either Newberg or Newberry, that those claims are inextricably intertwined to the normal gender cases anyway. But that wasn't before. That wasn't within the purview of the EEOC when Mr. Ernst filed his charge of discrimination. He completed the questionnaire. From the completion of the questionnaire, logic dictates that the EEOC will compose a charge. It was true and correct. He signed it under oath, but the question's fair notice. So why would I tell this court that Methodist had fair notice, not only because it was part of the intake questionnaire in the charge of discrimination, but why did Methodist have fair notice that Mr. Ernst was claiming a sexual orientation claim? Because in his grievance form that's part of the record, he cited that. So Methodist can't come before this court when I yield the podium and tell this court that this comes as prejudice or surprise to it. The scope of an EEOC charge have always been liberally construed. It goes back, the case not even cited in our brief, but I'm sure the panel's familiar with the old Sanchez versus Standard Foods case, which was 1970, which states that the scope of an EEOC charge can be what is reasonably calculated to stem out of the charge itself. I understand where they would be coming from with regard to the fact that the questionnaire is not the body of the charge itself. But
I think they're saying they didn't get the questionnaire.
I understand.
And do you have proof that they did?
No, we don't. But that goes back. It goes back. The question that I believe is a proper question to address is whether the fact that he would be claiming that caught them by surprise or if they're prejudiced. The recent cases state that. Vantage Energy, Federal Express versus Holowecki, which is a Supreme Court case, addresses the issue of surprise. And I would argue, or I am arguing to this court, that Methodists cannot come in good conscience to this court and say this caught us completely off guard because it was in the grievance. This is a very unique situation in that
which page are you specifically relying on?
On the grievance?
Yes.
I'll have to yield to rebuttal on that. I don't have I know that it's in our briefing, and I'm sure we can address that question in rebuttal. I know it's there.
Okay.
I'd be surprised if Methodists would have come up to this podium and say that it wasn't there. I think their argument, and appropriately so, is that it wasn't included within the charging paper.
No, I get that it's not in the charge. You also, in your reply, inserted a box 2 on page 8 of your reply, and in some 28J or something, they said, this is brand new, never saw it before. And I looked through the record, and I didn't see it either. Is that in the record?
I believe it is. I mean, I'm not going to stand here and assert it was. I believe I saw it in the record. I can't cite to it at this point.
Okay, because you didn't cite the record on page 8 of your reply brief. You inserted this, but you didn't cite, ROA dot whatever. And I'm not claiming to be perfect. I didn't see it.
Right, and I think the response would be that whether it was in the record or not, and I'm going to stand to three judges on the court reviewing the record as well as we did, but I think if you go back to the argument as to whether or not this catches them by surprise, I know the grievance part is there. So, I don't see, in a unique situation like this where the law clearly changed, I can't, and I'm not going to profess to get into the mind of the EEOC investigator who wrote the charge. In a typical scenario, when we generate charges and see the clients for the first time, we craft the charges itself, so when one of us come before a panel like this, we can fall on our own sword. This is not that situation. This was done before the law changed, and I can understand why the EEOC would not have included that claim in the charge at the time it was done, because that clearly wasn't the law. But
they had a check mark for sex orientation. I mean, the law hasn't changed. The congressional statute hasn't changed. What has changed is the construction of sex discrimination, and that box can be checked. There was nothing that prevented him from checking that. Correct,
but what I was just saying, and this was not a charge. It was a charge that Mr. Ernst stands by. He swore to it under oath. He had an opportunity to review it and sign it. But they're taking counsel if these charges are not prepared by independent counsel, they're taking the lead, if you will, of whoever the EEOC prepared the charge for them to sign. I could tell you clearly, if it was done by private counsel, the result probably would have been different. But that doesn't change the import of what's before the court. If you boil it down to the least common denominator, the purpose of a charge of discrimination is to provide fair notice so that the responding party is not prejudiced or surprised by the allegations brought against it in the charge of discrimination itself. Our position is that based on Mr. Ernst's grievance, this would, and liberal construction of what's likely to ground of the charge, this would not be prejudicially surprising to the Methodist Hospital. Now, if I can move to the second part of your argument, I want to make sure I've addressed the court's concerns. I understand.
Well, I was getting ready to cut you off only as a friendly comment that I think you have covered that, and you've got some other issues before you run out of time.
Right, and thank you, Your Honor. Well, then we look at the summary judgment part of the case. I think it's the simplest way I can phrase this. If you look at the district court's order, he found that the elements, the McDonnell-Douglas elements, were all satisfied because the court noted that Mr. Ernst was replaced by somebody outside of his class, and all we're left with is pretext. There's no status of protected class. The trial court did reference his competency to do the job and subjection to an adverse job action. The remainder basically is pretext. He was fired for a gesture. I'm not going to get into the graphics of the gesture, but there was in the record video evidence of the transaction in question. Video evidence that was there. The HR Human Resources supervisor, under oath in her deposition, said that she didn't see anything noticeable when Mr. Ernst was passing through this hallway or whatever the area was. And there is clear evidence in this case that, or the record is void of any prior discipline, anything to give rise to the fact that Mr. Ernst had any performance problems. His evaluations were all above standard. He complained about being bullied by his supervisor, who was actually Corbett, the comparator supervisor. I think the trial court made a determination in the body of the order granting summary judgment that Mr. Ernst was a senior traffic coordinator, and Mr. Corbett didn't have the senior designation, but one didn't supervise the other. Mr. Ernst didn't supervise Mr. Corbett. They were both supervised by a lady named Rivers, who was an African-American female who recommended his termination. The big issue, as we see it, is pretext. And again, I want to toe as delicate a line as I possibly can. The articulated, legitimate, non-discriminatory reason for the termination is that Mr. Ernst gestured in a way he shouldn't have gestured, adjusting himself. However you want to take the evidence that was in the record justifying the termination, but that creates, in my view, an inherent issue of fact, because they're saying that he did this, but then when cross-examined in deposition, the Ms. Coggins was her name, the human resources director, said that she couldn't see what was going on. Either the video evidence...
But the person who made the complaint is the one who said it happened.
Correct.
And, it wouldn't be the first time in history that some kind of harassment occurred that is not fully documented by a video. You can be doing things, and there's a video right now, and we don't see it because it's under the lectern or something.
Yes, you are. But in this case, they identified the transaction in question. They identified, as far as we could tell, time, place, and manner till it was narrowed to the point. This was not a video, Your Honor, that we had. This is a video that was turned over through the discovery process. So if there was more there, we certainly...
No, but what I'm saying is, videos don't always show... If you just had a camera right up there, it would only show some parts of this room. It might not show something that's hidden by a lectern, something that's hidden by a mask, something that's under a table, and so on. So what I'm saying is, you still have the person making the complaint, regardless of whether the video is showing everything that happened.
I completely understand the court's...
So why isn't that a reason to fire him? Because they believe the complainant over him.
Because there's evidence that shows that the complainant may have been mistaken. The complainant may have misinterpreted what was seen.
But that doesn't affect why he was terminated. I mean, a person can be terminated for something that never happens if the people who are making the decision for the employer think it happened and aren't just making it up.
Unless it's pretextual for discrimination. And that's the issue here. We had a supervisor of a different race who he had some issues with. There was that's documented in the file, in the briefing, Your Honor. And what Mr. Ernst said was that he not only didn't remember doing this, and the video hashed out. I can guarantee you one thing, Your Honor. If the video would have hashed out what was said, we wouldn't be talking in this context right now.
All right. Your initial time has expired, and
Thank you.
You've saved time for rebuttal. Thank you, Mr. Rosenberg. Okay, Mr. Patton, whenever you're ready.
May it please the Court. I'm here to discuss two issues with you today: whether the District Court properly dismissed appellant's sexual orientation, discrimination, and retaliation claims because of his failure to exhaust administrative remedies. And the other issue I would like to speak to you about is whether the Court properly granted summary judgment on appellant's race discrimination claims. The exhaustion of administrative remedies is a prerequisite to filing a lawsuit. It serves two purposes. A charge of discrimination enables the EEOC to investigate and then, if appropriate, negotiate a resolution with the employer. And a charge of discrimination puts the employer on notice of the existence and the natures of the charges against them. In this case, in his charge of discrimination, the appellant does not allege sexual orientation discrimination or retaliation in the charge, nor does the appellant assert any facts that would raise an inference that he was talking about sexual orientation discrimination or retaliation.
The charge listed only race, is that right?
That is correct, Your Honor. The factual statement contained is only about race allegations, and then he also checks the box for race only. There's not even a reasonable inference from the facts that are contained in the four corners of that document that would raise any suspicion or an inference that sexual orientation discrimination.
What about his argument about the grievance, that having filed a grievance with you all, then you are aware of his concerns?
So at Houston Methodist, Justice Haynes, they have an employee dispute resolution process. This is a 3-level appeal process for employees that have any kind of want to appeal an employment decision. Mr. Ernst avails himself of that process. During that appeal process, he did file charges, making allegations and stuff. And I will contend to you, he did make numerous claims, one of which was sexual orientation. However, when he did fill out the intake questionnaire, he addressed several claims such as age, sexual orientation, retaliation, and race. Only one of those made it to the charge, and that was race. And the purpose, as I just said, the two-prong requirement is, one, is to allow the EEOC to investigate and then, if possible, negotiate a resolution with the employer. And the second thing is to put the employer on notice. Well, the employer doesn't know what's outside the charge. Just because he might have done it at a level at the hospital and some appellate process there, that doesn't mean he's going to seek and go further with it with an EEOC charge. Because as the court is aware,
does it matter that you're not surprised? I mean, he's arguing that you shouldn't be surprised by this because you knew about it. So what do you say to that?
Well, I don't think surprise is really the test, Your Honor. If we look at the Federal Express versus Holowicki case, the Supreme Court of the United States came up with a two-part test to determine whether an intake questionnaire can qualify as a charge, which is what they're seeking to do in this case. And in the first part of that test, you got to fulfill the charge filing requirements. And then the second part of the test is you have to have something in the document, the intake questionnaire, that's a request to act. And although the Holowicki case was an ADEA case, this is a Title VII case. In a Title VII, charge requirements is a verification that is found both in the statute and it's also found in the EEOC regulations. We do not have that here. We have an unsigned, unverified intake questionnaire. So they do not meet the first element of the two-part test. Putting that aside, Your Honor, actually, if you look from the Patton case that this court found, you specifically said that this was an ADA case, but you relied on Holowicki, and you said that because an ADA charge must be verified, an unverified intake questionnaire alone cannot be deemed as a charge under the ADA. The same conclusion should apply in a Title VII case. there's a charging requirement of verification under Title VII and the EEOC regulations. But moving on to the second part of the test of Holowicki, it's a request to act. In the Holowicki case, they relied upon a 6-page affidavit that was attached to the intake questionnaire, and specifically in that case, Ms. Holowicki said in the 6-page affidavit to please force Federal Express to end their age discrimination. Justice Kennedy relied upon that statement as a request to act that met the second part of the test. We don't have that here. We don't have a request to act at all. In fact, Justice Haynes brought up the fact that they attached box number 2, which purports to be potentially from the intake questionnaire. Box number 2 is found in your EEOC Vantage energy case. You guys actually, this court actually talked about the fact that the EEOC changed its intake questionnaire to include that box. And they did that as a result of Holowicki. The Fifth Circuit actually specifically talked about the fact that that was changed. If a charging party checks that box, that would rise to a level of potentially a verification, and it would also rise to a level of request to act. Can I get some water real quick?
No problem. Take your time. It's okay. We have plenty of time.
Okay. So in the Holowicki test, in Vantage EEOC case, it specifically talked about that box. And in this case, they attempted to put it into the record. And Justice Haynes, I will represent to you that is not in the record. There was a footnote in the brief that suggested that maybe it was a clerk of a court error. I think that is a little unfair to put that before the court, that was an error. This document, the intake questionnaire, was attached to 3 different pleadings in the record. And in none of those 3 pleadings did the... Well,
it is a little weird because if you look at page ROA 53, there's a question 3, and then you look at ROA 54, and it's like question, 8 or something is the next page. It does look like they're saying that every other page was missing, but I'm not sure if that's a clerk error or if that's just what they filed.
Well,
and it seems weird that they didn't realize that until now.
And I agree, Your Honor, but keep in mind that it was also attached to ROA 76 through 80, which was attached to the First Amendment complaint. They also attached it in response.
It's the same thing over and over again.
It is.
The same thing that's missing what looks like a back page. And I don't know if that also includes the box or not. I mean, it's just kind of weird.
I agree with you, Your Honor, but I think the fact that it was attached to 3 different complaints, that to me, it doesn't seem to be a clerk of court error, that it would happen 3 different times with the same document. There are no other allegations contained in the record where there are potentially every other page being filed other than this intake questionnaire that was attached.
And did they try to fix that? I mean, have they gone to did they ever go to the district court and say, whoa, wait a minute, you're missing 4 pages?
No, the first time that it got attempted to be put in the record was attached to the reply on the last page of their brief, Your Honor. So, finding that they don't meet the Holowicki test, they don't meet either element number 1 or element number 2. However, I also think that this court finding that their intake questionnaire doesn't qualify as a charge also is supportive by the Harris versus Honda case, where this court talked about notice, as you mentioned, Justice Smith, is that there was no notice. There was no notice about these other claims. And if I could speak to the reason as to why he didn't maybe allege it and the allegation that potentially the EEOC couldn't have done it at that time, there's nothing in the record that suggests the appellant was not given the opportunity to put this in his charge. He also alleged in his intake questionnaire an age discrimination, which never made it to the lawsuit or the charge. He alleged a retaliation claim that was different than what ended up in the lawsuit. So unless there's something in the record that suggests he was prevented from alleging any kind of sexual orientation discrimination claim, I'm just purport to you that there is nothing in the record that suggests that, and that can't be considered by the court. It would be outside the record. moving on to the second aspect, which is whether the district court properly granted summary judgment in this case, Your Honors. As a prima facie case under race discrimination, a plaintiff must show 4 elements. Show he's a member of a protected group, was qualified for the position at issue, he was terminated or suffered some adverse action by the employer.
How do you address the video? Because he's basically conceded that if it was true that Mr. Ernst actually did what he was accused of doing, that firing him would be acceptable. But he's basically saying that was thrown into doubt by the video. What's your response to that?
My response to that is actually what you brought up, Justice Haynes, is the fact that the initial start of this investigation was from a third-party complainant. The third-party complainant. And so now we're into kind of a good faith belief test with regards to Wagoneer versus City of Garland. Your Honors, in that case, the central issue doesn't go to the validity of the complaint. The central issue goes to the decision maker and whether or not they had a good faith belief that the complaint was true. In this case, there was a full-blown investigation done. It was handled by human resources generalists, and then there was a recommendation for termination, and then the decision maker, Ms. Coggins, looked at the investigative materials. What they did not tell you, Your Honor, is that despite the fact that she did not watch the video, she did read and review a chronology of a minute-by-minute that was in the video of what happened. And just as you said, Your Honor, that not everything can be seen in the video. There were also interviews done by 2 people who were working at the desk. So them challenging the video, the appellant challenging the fact that maybe the complainant wasn't accurate, really doesn't go to pretext. With regards to pretext, you have to show that the reason that Houston Methodist came up with for termination was racially motivated. And there's no evidence in the record of any kind of racial motivation by Houston Methodist that would show that their reasons for termination were pretextual. The reasons that Methodist terminated...
I could envision a situation where they have a racist view of him, they want to fire him, and then they get this fake report of sexual harassment, and they fire him based on that, knowing it's fake. I'm not saying that's what happened here. I'm just saying hypothetically, I could envision that occurring. Since this is a summary judgment, how do we know that did not occur here?
Well, because, Your Honor, the evidence is, there was only 3 pieces of evidence that were brought before this court with regards to pretext. And in regards to that, Your Honor, the first piece of evidence that they bring up in their brief, fact 1, was that the hospital's human resource director, Ms. Coggins, made the decision to terminate appellants first for performance reasons, which she was later forced to retract as untrue. And then the second fact, which is coupled with number 1, is that the hospital then stated the appellant was not working during work hours and had to retract that reason as well. First, the appellant mistakenly tells this court that these were like initial reasons for termination, and then they came up with others. That's not what happened. During the employee dispute resolution process, Ms. Coggins, as a first-level appeal, met with Mr. Ernst, and he brought forth some evidence that demonstrated that those reasons for termination were not accurate because it was for him not being attended at his office when he should be at work time, and he demonstrated that he wasn't on the clock until later. So as a matter of fairness, Ms. Coggins recommended that the documentation of termination be changed and that those 2 reasons be eliminated. However, the 3 other legitimate reasons, his dishonesty during the investigation, his violation of the harassment policy, and then his violation of Houston Methodist eye care values that the hospital has, those 3 reasons still stood firm. And then finally, the last fact that has been brought up by appellant in their brief for pretext is that she talks about the fact that Ms. Coggins failed to watch that video that made the basis of the termination at the time of the investigation. And as I told you, Ms. Coggins, the evidence in the record demonstrates that Ms. Coggins looked at the investigative materials, and she also looked at the chronology, which is a minute-by-minute of the video. So she testified she didn't feel it was necessary for her to actually look at the video. But putting that aside, when we're talking about pretext, The key inquiry is whether the employer acted with discriminatory motive. And the question is not whether Houston Methodist made an erroneous decision by terminating an appellant, it's whether the decision was made with discriminatory motive. There has been no evidence in this record that has been brought forth of any discriminatory motive. The only thing that they do is that they challenge the actual validity of the complaint and the investigation. And, Your Honors, I would turn you to the Eagleton versus Texas Children's Hospital case, which is a 2020 Fifth Circuit case. In that case, Miss Eagleton was being investigated because she clocked an employee in when the employee wasn't there. There was a surveillance video. Her supervisor reviewed the surveillance. It wasn't crystal clear in the surveillance video that she actually clocked her in. However, she was the only one at the computer who had the access at the time that she was clocked in. Miss Eagleton's supervisor recommended termination to her supervisor. Her supervisor then reviewed the investigative materials, and then her supervisor terminated for violation of company policy, which is theft of time. On appeal, Eagleton only challenged the investigation and the results of the investigation. They did not go to the good faith belief of the decision makers' belief that they violated a company policy. And that's exactly what we have here. The only challenge that's being brought forth before you is the validity of the complaint and the validity of the investigation. And as you found in the Eagleton case, you found that there was no pretext because there was no discriminatory motive of evidence that the termination was based on race discrimination. And that's exactly what we have in this case, Your Honors. So we believe that with regards to whether the court properly found for the sexual orientation retaliation claims that Mr. Ernst failed to exhaust his administrative remedies, he didn't meet either element of the Holowicki test, and there was no notice to the employer with regards to Harris versus Honda and also in the Patton versus Jacobs Engineering's case. Also, Your Honor, we don't feel that the district court made any mistake by granting summary judgment because we met the prima facie. They did not meet their elements under the prima facie case, and if they did, they certainly didn't demonstrate any pretext to the decision made by Houston Methodist with regards to the appellant's termination. So if I have no further questions by the panel, I will yield my time.
Thank you, Mr. Patton.
Thank you.
And rebuttal, is it Ms. Sprovach?
Good afternoon, Your Honors. Judge King, Judge Smith, Judge Haynes. My name is Ellen Sprovach. Close, Your Honor.
Ms. Sprovach, all right.
Thank you. I appreciate the opportunity to present James Kenny Ernst's case before you. A couple of things before I work my way through some comments. I want to follow up with what Judge Haynes asked previously. You asked about the grievance that Mr. Ernst filed. He did file a grievance. It is, for the record, pages 326 through 328. It was on January 26th, 2016, and in that grievance to Methodist, he specifically said that he believes that his sexual orientation was part of the decision, and as well as his being a homosexual. The words exactly were that he thought it was a motivating factor in his termination decision, and I believe my sexual orientation has been going on concerns with management, as I have been asked by other employees whether or not I am a homosexual. So Mr. Ernst did make Methodist aware. Judge Haynes, you also referenced that cut out about the checkbox. I always tell my clients, to be credible, you have to concede the truth. And the truth on that is not in the record. So I don't want to make any misrepresentations to the court that checkbox was not part of the record. If I work my way back briefly through what you all were talking about with regard to the summary judgment standard and the race claim, Mr. Ernst is a Caucasian. He was fired, so he's got his two elements of his summary judgment standard. He was treated less favorably than Gregg who is African-American, and ultimately he was, this is kind of interesting, replaced by Mr. Kubit by way of Methodist asked Mr. Kubit if he wanted the job, but Mr. Kubit didn't want the job. So I think that's a nuance that is a fact issue.
I thought the records show that his jobs, his various responsibilities were distributed among several co-workers rather than his being just replaced by one person.
You're correct, Your Honor. Ultimately, they were that, but that was only after Mr. Kubit refused to take the position, and that is in the record, and Methodist has never disputed that. Mr. Kubit was ultimately terminated for being not credible on another issue briefly thereafter. So we've got the treated less favorably part because Mr. Kubit had 2 sexual harassment claims against him. And Mr. Ernst actually participated in those investigations, and Mr. Kubit was not fired. So we've got the less favorably part and the replaced part. So I believe we've met that part of the prima facie case, Your Honor. When we get to the termination and the exhaustion of remedies, it gets a little tricky. This court released a case about a year ago, April 3rd, 2020, the Vantage Energy case. That was with the Eeoc. And that actually expanded Holowicki. So if you go into this case, it says, the quotes specifically are, it would be illogical and impractical to make the definition of a charge independent upon a condition subsequent over which the parties have no control. And by way of that, Mr. Ernst went to the Eeoc. He filled out his questionnaire. And in the questionnaire, he was very detailed, specifically on page 55, about sexual orientation being part of the termination. So Mr. Ernst relies on the Eeoc. And so the Vantage case basically says that treating the intake questionnaire as a charge would violate due process because it didn't receive notice, but only if there is, Methodist here would say that there was prejudice to them as a bar to this claim. Methodist has never in this brief asserted that there's any prejudice and not shown this court prejudice, but by the way, we also answered the question about the grievance giving notice. So they fail. Methodist fails on their burden to say that it's prejudicial to them. With regard to the video surveillance, the problem with this whole termination issue is on the record on page 64, Ms. Coggins, who is the HR director, says, based on the documents obtained along with the review of video surveillance, there is evidence to support your actions. She actually said based on a review of video surveillance, but she didn't review the video surveillance. And the video surveillance was wide open. Hallways you could see everywhere, nothing was hidden. Ms. Coggins didn't look at that video until her deposition. In fact, they never even provided to Mr. Ernst. So Ms. Coggins says, I don't see anything in there that's bad or terminable. So the fact is we've met the summary judgment standard, and we've shown the court that Mr. Ernst exhausted his administrative remedies according to Vanguard, and we ask at the very least that this case be remanded for further proceedings. And thank you for your time, Your Honors.
Thank you, Ms. Sprovach. Your case and all of today's cases are under submission, and the court is in recess until 9:30 tomorrow.